Daly.
Just maybe a couple of quick questions, and I think the module is really important because it's dealing with the impact of Ireland's international legal obligations in terms of our domestic law, and in that sense some people might present international law as a sort of an optional extra. You might deal in a little bit more detail and to explain why Ireland is actually bound by these obligations when we talk about violation and we talk about the state being sued, that you might explain that a little bit more. When we were here last week, there was a lot of discussion around the issue of legal uncertainty and so on in terms of the constitutional dimensions of abortion law. I suppose my question would be, have international bodies been concerned by the uncertainty in Ireland's present abortion law, and maybe to tease that out a little bit? The last two quick questions. One is decriminalisation, which actually isn't in the report of the Citizens' Assembly, despite the fact that many citizens asked that it would be, and it's an issue that we raised with Justice Lafoy. Now, she seemed to be of the opinion that, well, it didn't really need to be in there because if the law is changed, it's going to automatically follow. But I think you might expand on that, because you're very clearly saying, from an international human rights legal perspective, abortion must be decriminalised in all circumstances, regardless of what legislation might follow a referendum. And the last question is just in relation to the Commission's view that we need to develop an approach as a healthcare matter. Now, traditionally in this state, Irish maternity care was dominated generally by the Catholic hospitals and so on, Catholic doctors developing the medical ethics that exist in this state. I suppose if you had the chance of explaining how international human rights law requires us to balance women's rights against institutional and personal religious freedom, and how that is balanced, if you like, in other states.
Deputy. Ms. Logan, did you want to?
She was going to take that. Hold on. Thank you very much, Deputy Daly, for the questions. First of all, if I can go through those. With regard to our international legal obligations and the status of international law, I think that's the core of the question. When Ireland ratifies an international treaty, it accepts a legal obligation in good faith to implement that treaty. So it's a sovereign decision taken by the state to ratify a treaty and thereby to comply with it and give effect to it, and that's part of international treaty law. So we have a good faith obligation, that's the terminology used, to give effect to our obligations under international treaties and to ensure effective remedies in any case of a violation of those treaties. And with regard to decisions then, for example, of a UN human rights treaty body, as in Mallet or Whelan, those are authoritative interpretations of the bodies that are competent as a matter of law under the treaty, under the relevant treaty, the Covenant on Civil and Political Rights, to interpret those. And not only have we ratified the Covenant on Civil and Political Rights, we've also recognised the competence of treaty bodies to receive and consider decisions and to give their views on those. So that was an additional step that we took in ratifying the first optional protocol to the Covenant on Civil and Political Rights, for example. So we have, as a state, accepted those obligations as a matter of law. The second question was with regards to uncertainty. And I think, as was also said last week, it's not possible as a matter of law with any legal text to achieve absolute certainty. But the protections that are afforded should ensure that a woman has effective access to a lawful abortion, that decisions are made that are timely, that procedures are accessible, and that was precisely the problem in the ABC case with regard to the third applicant C, where there was a finding of a violation of Article 8 of the European Convention on Human Rights, where it was not possible, the court found, there had been no access to an abortion that was lawful in Ireland. And this has come up also in the cases in relation to Poland before the European Court of Human Rights. Again, that there was such a lack of clarity that women and girls had been subject to humiliating situations, moved around from one place to another because of the absence of timely and effective access to lawful abortion. So that level of uncertainty has been referred to as a chilling factor, both for medical practitioners and for women and girls with regard to their lawful rights to abortion. The third question, with regard to criminalisation and decriminalisation, we referred in the policy document and also in our statement specifically to the views of the UN Committee on the Rights of the Child in 2016, where they called for decriminalisation in all circumstances. And again, this goes directly to the point around access to a safe and legal abortion being part of the right to the highest attainable standard of health, and the need to ensure that the criminal law does not act as a barrier to access to health services. And the final question, I think, was in relation to conscientious objection and religious freedom. And here, in the extended policy document and in the submission also that we had made earlier to the Citizens' Assembly, we refer to the relevant provisions of international European human rights law, also with regard to the Polish decisions from the European Court of Human Rights, to the collective complaint from the European Social Rights Committee, that how healthcare services are organised, while there must be recognition of the right to conscientious objection, that health services must be organised in such a way that there is effective access, so that a health service provider, a medical practitioner, must ensure onward referral to a non-objecting practitioner, and that any right to conscientious objection, of course, should not impede the right to life of a woman and to their lawful rights under an abortion regime. So there is an obligation of onward referral. Reference has also been made in the Polish context to decisions being given in writing to be justified to a greater level of transparency and clarity to avoid that kind of confusion and uncertainty for any woman or girl seeking access to a lawful abortion.